The law is well settled that for a contract to be established, there are certain elements that must be in existence as at the time of contract and negotiation. They include the offer on the part of the offeror, the acceptance on the part of the offeree, the intention between parties to be legally bound, which is inferred from the circumstances surrounding the creation of the agreement, the consideration, which is something of value that is mutually exchanged between parties, and the capacity of parties to contract, which is a question of law. But it is important to note that this legal rule that I just established now is not absolute, as even in the existence of this essential element, a contract can be cancelled, a contract can be voided, a contract can be unenforceable, and in the context of our topic this evening, a contract can be vitiated. So the vitiating element of a contract refers to those specific factors, those specific elements, those specific state of events that has the capacity to cancel, render void a contractual agreement, like I said, even with the existence of this essential element. And for the purpose of these lectures, I would just briefly summarize the vitiating element of a contract so I can provide a roadmap that you can use for your study and a proper understanding of this specific principle of law. What is the vitiating element of a contract? The vitiating element of a contract simply refers to, like I already explained, those specific facts, the existence of a particular fact, the occurrence or non-occurrence of a particular state of event that has the capacity, because of the nature of that particular fact or event, cancel an agreement. And when a court, after a proper examination of a specific contractual agreement, discovers that there is a vitiating factor, it has no other option but to cancel and render that contract as one that is invalid, void, and of no legal effect. They simply consist of the mistake, the misrepresentation, the duress, and the undue influence. These are different vitiating elements in different contexts and subject matter. What is the mistake? It is important to note that one of the important and requisite conditions for the creation of a valid contractual relationship is actually the existence of a consensus ad idem. The consensus ad idem is a rule that says that the minds of the parties with respect to every contractual agreement must meet and be consistent with each other, such that if there is no consensus between parties, if parties as at the time of entering an agreement are not consistent with respect to a particular state of affair, then that contract will be voided simply because they were operating on the basis of a mistaken belief. So the essence of the mistake as an element that vitiates a contract is that contract will be voided, contract will be vitiated, contract will be cancelled when parties did not satisfy this condition of the consensus ad idem. So when we are saying there is a mistake with respect to a contractual agreement, we are simply saying that parties to a contract were actually operating on the basis of a mistaken belief or identity. And there are different kinds of mistake. There is the common mistake, there is the mutual mistake, and there is the unilateral mistake. In the common mistake, the both parties are actually mistaken with respect to a particular subject matter, to a particular thing. Both parties are entering into an agreement, but what they originally intended by virtue of entering into that negotiation is not what the state of affair is. So therefore, they were operating on a mistake, and that mistake that they were operating from is common to both parties. It's consistent with both parties. That is why it is called a common mistake. But in the mutual mistake, both parties are mistaken with respect to different subject matters. It has been established that both parties are mistaken, but their mistake is with respect to different things. But in the unilateral mistake is only seen in the mistake most times as to the identity of a specific person on the part of one party alone. That is the essence of mistake. That the consensus ad idem, the requirement of a consensus ad idem between parties was not satisfied because they were operating on the basis of a mistake. So the court would see it as inequitable to enforce a contractual agreement against a party, against parties who never intended the state of affair that is supposed to serve as the basis for the enforcement of that agreement. both parties did not intend to engage in such, because they were intending to engage in another specific state of affair. And because of that mistaken belief, because of that mistake between parties, the court would void and render that contract as invalid. But the misrepresentation, on the other hand, is another element that vitiates an agreement. It is simply one that is committed. It is one that is done when a representation is made. Unlike the mistake where parties are mistaken with respect to different things, the misrepresentation simply consists of an element that vitiates an agreement when a party in a contract makes a representation either by words, by writing, or by conduct with respect to a particular subject matter, and after that contract was entered into on the basis of that representation, it was found that that representation is actually false. So when two parties enter into an agreement and a party represented that this is the state of affairs, this is the situation of things, and that other party entered into an agreement because of that initial representation, and it was found out that this representation is actually false, the court would not enforce that agreement because this vitiating factor, the misrepresentation, is in existence. And there are different kinds of misrepresentation. There is a fraudulent misrepresentation, which refers to the misrepresentation that is committed with a fraudulent intent, that is, with the knowledge of the falsity of the statement or indifference as to its truth or falsity. The negligent misrepresentation, as established in Edinburgh and Co. Limited versus Ella and Partners, simply refers to the representation that is made with carelessness. The person who made this representation is careless as to its truth or falsity. And the innocent representation is one which actually don't attract any remedy. It is one that is made innocently. That is what the misrepresentation is. The representation that is actually false, which leads to damage as a result of the innocent party's reliance on that representation. But the duress and undue influence is another vitiating element in another different context, because generally in law, courts, before any contract can be enforced, must be satisfied that the person who entered into that contract actually consented to the terms of the agreement, and the duress and undue influence is actually a factor that hinders this particular condition that has been set out by courts. You already know that duress in law generally simply refers to a force or a threat to use force. And when a party is forced to enter into an agreement which he normally wouldn't have entered into if that force wasn't made to him, or that threat to force wasn't made to him, the court would refuse to enforce it, because that requirement of consent in every contractual agreement has been cancelled, has been vitiated. So the duress is simply the widened scope in common law that voids any contract that was entered into when a force or threat to use force is made against the innocent party. So if there's any contract that you entered into against your will, against your consent, you just entered into that contract because you were forced, there was a threat to use force on you, your siblings, your property, or any other thing that has the capacity to vitiate your consent, you have the legal capacity to vitiate that, to cancel, terminate that agreement, seeking the available legal remedies. But the undue influence is simply a widening scope of duress, because in some situations there is the lack of a force or a threat to use force, but the court will still refuse to enforce that agreement because there was an improper use of pressure, there was an improper use of authority. Lord Denning calls it the inequality of bargaining power. As long as in that situation the court have examined the relationship between parties and found that there was an improper use of authority on the part of one party, there was an improper use of pressure on the part of one party, which led the other party, who is actually the inferior party in most circumstances, to enter into that agreement, the court, on the basis of an undue influence, would refuse to enforce that particular agreement. That is what you need to know about the vitiating element of a contract. It simply refers to some factors, some facts, some events, some occurrence that tends to cancel, vitiate, and make void a contractual agreement. Like I already said, the fact that the 5 elements that makes for a valid contract is in existence is immaterial once these specific vitiating factors are established. Thank you so much for your time. Do well to follow us and subscribe to the M's Legal Nuggets media channels to be updated when more insightful nuggets and legal tips are sent.